is a quite distinct from a conventional patent. It is enforcement, the right attached to it, the benefits attached to it. So we have to understand the SEP in the context of its origination, its implementations, and the beneficiary. I will deal with those issues in the coming round.
You allow me to add to what they said, or you want to go back?
Yes, but I also want you to add, Sheetal, like now we look at from the round 2. Please also add on the issues that comes up on this SAP, and specifically if you want to draw light or draw parallel things with ICT, development in ICT technology, then please do so.
I'll try to respond to your question also, but I'm quite tempted to respond to what my colleagues on the panel have said. And it's not a fight, but it's what we observe when we work in the ICT sector and what is right and what is wrong. I think while in my past incarnation at FICCI and CI also, what we have seen is that there has to be a moral fabric change, first of all, in our country, that whether it's a standard essential patent or a normal patent, a conventional, unconventional, whatever, if it is used by anybody, there has to be reasonable remuneration that has to go. As simple as that. At the time of patent examination, it is not known to an examiner whether the patent is an essential patent or a conventional patent. Not only to the examiner, but also to the patentee. He himself doesn't know that after many, many years, this patent is going to get converted into an essential patent or not. And therefore, whenever an examination happens, there is no discrimination. Both undergoes a very comprehensive examination. At the end of the many, many years, whatever comes out is a patent which is granted by the federal government. Correct? That's one thing that I just wanted to clear. Second is that, as per Article 27 of the TRIPS, it says that the rights of the patenting, first of all, patent should be available in the member states without any discrimination to the place of technology and the type of technology. Correct? And if somebody is saying that because it is an essential patent and these should be categorized as a separate set of patents and the right should be restricted, it is going to be violative of TRIPS, number one. Second, it is going to be ultra-virus to our Section 48 of the Patents Act, which grants certain rights to the patent. That's another thing that I wanted to just say. And third is that the economic compensation, as somebody said that it's only the economic compensation that is important for the holders of the SCPs. Not only it is important to have an economic compensation, but at what time? That is even important. When we look at 1G to 2G to 3G to 4G and now to 5G, not even a decade's time it has taken for these technological advancements to happen. Think of no money coming back to the companies, to remain in the business, in the noble cause of coming up with the best of the technologies for the consumer welfare. India today has reached second position in the globe in terms of mobile telephony market. In terms of infrastructure, we have received 8th position in the globe and 4th in the Asian market when it comes to the infrastructure. It's all because of the FRAND licensing, and it is only because of the standard essential patents, because as SK rightly mentioned, that they don't keep an exclusivity with them. Right on the day one, there is a compromise made, a written declaration given that I'm ready to give my patent to you on a FRAND terms and conditions. It's not something that I own a patent and I'm saying, you know, it's available at every value chain. I'm saying it's available, but it has to be licensed at a particular value chain, not at every level. So we need to understand that standard essential patents have done great wonders to our country. Many of the Indian companies which were not even known 15 years back, they are there in the country today. Not only they have entered, but they are growing by leaps and bounds. In the past, from 2007 to 2009, and when we are speaking now in 2016, their profits had tripled by more than 25%. So I don't see any problem, whether it's a patent, conventional, or an SCP. They are doing wonders to our country. And the last point that I wanted to say that it's not a political issue. It's not something which is non-transparent. As far as I have understood, and I've also participated in some of the meetings, even at our own TSTSI, which is Telecom Standard Development Institute, everybody is free to come and walk in and contribute and also be part of the discussions. There's absolutely nothing which is going politically behind it and try to create a scene. India has been the key beneficiaries and it will remain to be if we follow the FRAND rules and the terms and conditions in a right way. And the last point that I wanted to say is that almost nobody has tried to pick up that issue that the injunctions form a very important piece in order to ensure that the other party who wants to seek a license behaves in a good faith. Because after 10 years, we all know there are 30 million cases which are pending in the court of law. Many, end up only in the trial stage, don't even go to the full trial. Look at various cases that are happening. If we have to wait for 10 years and court decides in favor of the SEP holder and the money starts coming in after 10 years, would it do any benefit to any of whether the government or the SEP holder? Is that what I just wanted to mention? So it's absolutely a safe haven if we do not allow any kind of a deterrence on the people who are the unwilling licensee, and otherwise there is no problem.
Right. Yeah. Thanks. Of course, this is the round where we're discussing about issues. We start seeing though at the first thing, when we're looking at what is standard essential patent, the role of standards and things like that, looks like good. But then, on the practical thing, we start seeing issues. At this point, Patrick, we want to go to you. On Sheetal mentioned about one of the things that she was talking about is FRAND thing. So, tell us or give us some insight into FRAND licensing and the challenges associated with FRAND licensing.
Yeah. Well, as Kay mentioned earlier, that there's this competing interest between the SEP holder and the SEP implementers, and that's exactly right. They have divergent concerns, and so the real trick in SEP patenting, and by the way, SEP patenting is a very good thing. SEP patenting promotes innovation. It adopts a standard that It promotes a standard that's adopted by many technology companies, and then those technology companies are all operating from a higher baseline from which they're now innovating. So rather than having competing technology companies trying to develop alternative technologies, everyone's operating on the same plane, and innovation, theoretically, and I believe in actuality, just proliferates, and that's a very good thing. But the trick in dealing with these divergent interests of the SEP holders and the SEP implementers really comes down to the FRAND. What is the FRAND rate? What's the royalty base and what's the royalty rate? And if the holders and the implementers are too diametrically opposed in terms of their anticipation or their expectations, there's problems. And what we're seeing, I think, is one of the biggest problems is what's called the reverse holdup situation. So if I'm the SEP patent holder, I can create what's called a hold-up situation. I can refuse to license my patent because I don't feel like I'm getting the appropriate terms from my implementers. That really doesn't happen. That doesn't seem to be the big problem because, as we've all said, people submit their IP to the standard because they want to develop a royalty revenue stream. So hold-up doesn't really occur all that much. The reverse hold-up situation is when the implementers refuse to pay a royalty. They believe that the royalty that's being requested by the SEP holder is just astronomically high and beyond the scope of what's reasonable, and they just won't pay it, and the only way they're going to come to the table is if they go through a multi-year extensive litigation, and that's a problem. And that's something that we've seen not, I would say, it's not rampant in the United States, but it's definitely a problem, and it's been the driver for the handful of cases that have come before our federal court system. It's these refusals to take reasonable licenses. So to get to Senthil's question, what is the reasonable royalty? What should it be? How do you determine this? Well, all of our, I'm quite certain that all of our jurisprudence in the United States, the decisions that we've seen to date on this issue, have all come around to applying a test for determining what is the reasonable royalty. And basically, this test goes back to a case, it stems from a case that's almost 50 years old in the United States, a Supreme Court case that's called, that involved a party called Georgia Pacific, and there are licensing. There's two ways to gain damages in an American litigation. You can claim a lost profit if you're producing product and someone's undermined your ability to generate profits off your intellectual property, but that doesn't apply in the context of a standard essential patent regime. The other mechanism for damages is to assert a reasonable royalty. In the case of standard essential patents, this reasonable royalty is the base that the court uses for determining damages. But the mechanism is somewhat modified. All of our courts who've dealt with this reasonable royalty, what is the FRAND rate, have applied this Georgia-Pacific case in what they call a modified version. And what they mean by modified, well, to give one example of what they mean by modified, some of the factors that go into the Georgia-Pacific determination are, did the SEP holder license this to other parties, and if so, under what terms? What are some of those other license agreements look like? What's the nature of the competitive landscape? But that's not quite as relevant in the context of SEP because it's, as we've all said, it's a different type of landscape. It's one where the patent owner has agreed to license their patents. Another factor that's in these Georgia-Pacific factors, though, is what's called the hypothetical negotiation. So you want to look at what would a willing licensor and a willing licensee who are sitting at the table negotiating arrive at as a reasonable royalty for the technology that's involved. It's a little bit modified hypothetical negotiation because our courts have said that you have to look at how these two parties would negotiate had the patent not been adopted as a standard essential patent. And that requires a great deal of putting up the magic ball, the crystal ball, and trying to determine how things would have been some time ago in the past, and without this wide industry adoption. So, again, to summarize, you have the divergent views of the SEP holder and the SEP implementer. You have the resolution, which is the FRAND licensing framework. In the United States, that FRAND licensing framework is driven by our Georgia-Pacific factors, slightly modified, and because they're modified in a way that requires going to a crystal ball, it doesn't always solve the problem. And I think it's why, and we can get into this a little bit later, but my next comments are going to be, as I hope our conversation turns in this direction, is why injunctions are really needed to be available to parties. And they're largely not available in the United States for SEP patents, but I think they need to be to address this reverse holdup problem that I mentioned and to force parties to come to a quicker resolution as to what is the FRAND value. And that's where I will take my conversation next time the microphone's in my hand.
Right. Thanks. I see now it's like I'm interested what Sanjeev and Sai has to tell on this.
Yeah, I will pick up where Seetal stated we have not spoken on the injunction and then certainly on the FRAND and what could be the reasonable royalty. I agree with Seetal to the extent that injunction in the Indian scenario could be necessary. However, in my opinion, there should be a great amount of caution when it is a case of ACPs. Why that is so? We all agree that the ACP owner stands on a very, very high pedestal. He commits to license his ACP on FRAND rates. Now how far he has been honest in his commitment to a defendant who is the party in the list, that has to be tested before an interim injunction to be granted. So now, once we talk of injunction in India, there are three kinds. One is ex parte, second is interim after hearing both the parties, and third is certainly after trial as a permanent. So there should be a distinction between ex parte and an interim injunction. I agree with Seetal so far as the interim injunction is concerned, considering the time lag in India in deciding a particular case, and the trials may be 10 years, maybe 12 years, maybe 7 years. But an interim injunction, upon completion of pleading, can be decided in 6 to 9 months' time. Now, the court will have the occasion to see whether the plaintiff, as ACP owner, has approached or has performed his part of obligation as part of his commitment to the SSOs. He had negotiated with the ACP implementer on reasonable terms or not, and the implementer has refused to come to the reasonable term. If he plead and show a prima facie case on that respect, and then the defense, the prima facie defense of the implementer regarding the essentiality and the invalidity is tested by the court. I'm not saying the trial and the complete trial. I'm saying just a prima facie view, the stand of both the parties. Why? it is only because the SEP stands on a higher footing as from the commercial point of view, or also from the beneficiaries. You see how many beneficiaries are affected. One standard is affecting a particular segment of consumer. So the interim injunction, yes, necessary if the implementer is not open for a negotiation of an interim royalty or a FRAN term. Fully agree. But ex parte injunction in SEP case, I have my own reservation. I may not agree unless and until, in a rare circumstance, in a rare case, the plaintiff comes and shows to the court, here is a plethora of document I have written to this implementer n number of times, giving this option, providing this option, and this is the reasonable rate of royalty for this particular technology. That could be the rarest of the rare case. But in a normal situation, interim, yes, but ex parte, maybe no. This is one. Coming to Patrick, on the factors laid down in the Georgia Pacific case, and now those applied recently in 2015 in the Cisco and other case, the critical issues which has been, remain there in the US courts and also maybe in the Europe and India, we are just testing that whether the rate of royalty should be based on the end product or it should be restricted to a smallest sellable component to which the patented technology relate. This is a critical question which the courts have been juggling around. Now in India, we have seen it is device-based, is the end product. We all understand that there could be the two probable argument that one standard essential patent, though maybe driving only one of the aspect of that particular the system. However, in the absence of that, entire system cannot work. That is one argument. Second argument is this: there are n number of standard essential patents to make that system functional, and this particular SEP is essential to one particular aspect of the technology in that system, and that particular aspect relate to a particular component, and that component can be identified. The price of component can be identified. So this is another issue, and probably the Cisco, which answered this issue based upon the modified factors of the Georgia Pacific, could be one of the guidelines in the Indian scenario, or maybe the end product. But that is always a debatable issue. I would like Sai to have his view.
I'm actually grateful to Sheetal for opening up a host of issues, because I couldn't have asked for a better backdrop. So let's do this. One, a few disclaimers. No point that I'm going to make is based on emotion, nor will it be based on rhetoric. I will use specific legal pegs to make my point. Two, I will justify the position solely based on the framework of Indian law and use foreign jurisprudence only to support the position of Indian law. Why is this necessary? Because the fact of the matter is, what is FRAND in an Indian context does not have any guidance from Indian courts. The aspect of IPR policies of standard-setting organizations and their legality has not yet been tested in Indian courts, except for the patentee himself saying, no, I am bound by this. Apart from that, there is no legislation which says that we recognize these policies as having some force of law. So I will have to make my case purely on the basis of Indian law. So let's do that step by step. It's interesting that on the one hand, where they have to explain and urge the audience to understand the amount of investment that has gone into the development of a standard essential patent, they choose to focus on the fact that it's a standard essential patent. But the moment it comes to the enforcement of a standard essential patent, they say, no, Section 48 of the Patents Act, which speaks of enforcement of patent rights, applies uniformly regardless of what patent, whatever patent it may be. So if that is the logic, let's take this step by step. Indian law, and this can't be refuted. The four-step test that is to be observed in the grant of interim injunctions when it comes to patent matters is this. Point number one, the patentee will have to establish prima facie validity of the patent. Because under Section 13(4) of the Indian Patents Act, unlike the US patent framework, we don't grant or we don't bestow any presumptive validity on a patent merely because it's been granted. So the buck starts and stops at the patentee as far as validity is concerned. Second, the second limb of the test in the grant of an interim injunction is that it is for the patentee to establish prima facie infringement. That's point number 2. 3, unless and until you will suffer irreparable harm if an injunction is not granted, you have not made a case out for grant of an interim injunction. Therefore, irreparable harm will have to be established. 4, balance of convenience will have to tilt and sway in favor of the patentee in order for the injunction to be granted. These are the 4 limbs of the 4-step test. When it comes to a patent or a standard essential patent, let's take it specifically with respect to standard essential patent. This is something that I want audience members to clearly understand and appreciate. The aspect of validity of a patent is very different from the aspect of essentiality of the patent. Essentiality of the patent is directly connected to the aspect of infringement. Therefore, it is connected to the second aspect of the test. Whereas the validity of the patent is a different question altogether, which needs to be tested within the 4 corners of the Indian Patents Act. Whether or not the patent has been validly granted, whether it claims patentable subject matter, so on and so forth. And since the Indian Patents Act grants multiple mechanisms to challenge the validity of the patent, that needs to be addressed first, because if your patent is not valid, if the right is not valid, there is no question of moving to the second issue of infringement and enforcement. So that needs to be tested. So your patent may be absolutely essential. Let me even take that for granted. I completely give it to you that your patent is absolutely essential. Does it mean that it's valid? I'm sorry. These are 2 different issues. So that has to be tested. So the court cannot use essentiality, infringement as prejudice points when it is assessing the issue of validity, because the issue of validity will have to be addressed on its own merits independently. That's point number 1. Second,